Hello, welcome to this recording. My name is Eva Michaela. I teach at the London School of Economics, where I'm a professor and my area is corporate law. Let me begin this presentation by apologizing for the fact that I'm not able to be in person or on Zoom at this wonderful event. Unfortunately, I can only take part through this recording. So my job today is corporate sustainability due diligence and the UK perspective on this topic. I'm going to touch on three sub-questions. The first one is integrating stakeholders into directors' duties. The second one is due diligence requirements in criminal law, and underpinning both of these are reporting requirements, which I will also touch upon. As you're obviously aware, the UK is no longer a member of the European Union, but the modern developments of integrating due diligence into corporate requirements has of course also taken root in the UK. And it's this idea of ensuring that corporations do the right thing by requiring them to have procedures that prevent harm. And so that's the one element of it, and then the other one, which the EU's Corporate Sustainability Due Diligence Directive is also attempting to implement, is integrating stakeholders into directors' duties, and as you can see, we'll talk about that as well. Okay, let's talk then about the integration of sustainability or stakeholder interests into the duties of directors. The section to look at in the UK is section 172 of the Companies Act 2006, which has received a lot of attention internationally, also in the discussion about how can we steer directors to do more than enhance the interests of shareholders. So what I've given you on the screen here is the subsection 1. A director of a company must act in the way he considers in good faith would be most likely to promote the success of the company for the benefits of its members as a whole, and in doing so have regard to some other interests which I will come to shortly. So what do we see here? Well, so the first thing that this provision is interesting for is this idea that what needs to be promoted is the success of the company. And that's mentioned in the first instance. And then the next thing to note here, it's sort of promoting the success of the company for the benefit of the members as a whole. So the members as a whole come before the interests that directors are to have regard to. So there is a priority, members before other interests, but that isn't a very strong priority. And the reason I say this is it is the members as a whole. So it's not the preferences of individual members or of sort of, so while members under certain circumstances can give directions, it doesn't mean that the directors have to sort of request input from the shareholders. But the more important point is in good faith. So on the first line here, we see that between two commas, we see a requirement for directors to act in good faith. What that provision then really does is it establishes a very low standard, because all the directors have to do is they have to honestly believe that what they're doing is promoting the success of the company for the benefit of the members as a whole. So that's a subjective requirement. The courts do not review the content of the decision in substance. The courts only test whether directors honestly believed that what they did was promoting the success of the company. And how it's tested is if there's no evidence of dishonesty, honesty is assumed. So what we're seeing here is a provision that puts members first, but in a very moderate way, and actually puts the decision making into the court of the directors. Now, what are the have regards? The have regards are having regard to the likely consequences of a decision in the long term, the interests of the company's employees, the need to foster business relationships with suppliers, customers, and others, the impact of the company's operations on the community and the environment, the desirability of the company maintaining a reputation for high standards in business conduct, and the need to act fairly as between members. So that's the 172 package, which I understand has given some inspiration for the Corporate Sustainability Due Diligence Directive and its current draft. Now, there's more to say on 172. So 172 subsection 2 talks about companies that have specific purposes. So it says where and to the extent that the purposes of the company consist of or include purposes other than benefiting the members. Subsection 1 has effect as if the reference to promoting the success of the company for the benefit of its members as a whole were to achieving those purposes. That opens a door, is a flag towards saying it is possible to establish a company without an orientation towards the benefit of the members as a whole. So in a sense, in the UK, we don't need a sort of benefit corporation model, because the Companies Act 2006 makes it possible to give a purpose to a company in a way that replaces the members or the benefit of the members as a whole, and then it is a benefit corporation. And then there's subsection 3, which I won't say very much about, but that section preserves common law, preserves case law, and we've just had a recent case applying that section, and the law is about in circumstances in which the members' interests disappear from the director's radar and are replaced by creditor interests, and that's the case that I mentioned. We mentioned it as the Sequana case. But what subsection 3 then does, the duty imposed by this section 172 has effect subject to any enactment or rule of law being the common law, requiring directors in certain circumstances to consider or act in the interests of creditors of the company. Now, the question then is one of how is this enforced? The enforcement is, like with all other duties, it's enforced by the company. Very likely enforcement will then occur either when the directors have changed, so the existing directors are removed by new directors, the new directors enforce claims against the previous directors, or when the company has become insolvent and the liquidator is attempting to enforce claims against previous directors. Or of course in the context of company directors disqualification, which is a specific UK procedure where directors who have proven unfit to be concerned with the management of a company will then be disqualified. So that is a sort of a procedure funded by the government, or where directors are then issued with an instruction by the court that they must not involve themselves with managing the business of a company. So there is enforcement in circumstances, and that happens in circumstances where companies have failed. On an ongoing basis, it's not very likely that the shareholders enforce this. And moreover, from the or rather, let me put this slightly differently. On an ongoing basis, it would be for the shareholders to enforce it. The stakeholders, so the constituencies which integrate the have regard constituencies, for them, they don't have standing, so they cannot enforce section 172. So that's the main message here. What there is, however, are reporting requirements, and that is a a sort of regulatory tool that is not uncommon in the UK. And the idea there is that the directors need to produce reports, and those reports have a number of effects. So one effect is to require directors to consider the topics they need to report on. And given that they need to write a report, they need to do something that enhances the interests which the report concerns. So there's sort of a prompt to carry out activity related to the topics that you need to report on. And then, of course, there's enforcement through civil society. The idea being that if a company in its report describes itself in very favorable terms, when in fact the local constituency has a number of complaints, the employees are treated badly, there is then a possibility to use civil society, so to use social media for the press to become active, to hold companies to account and sort of compare what they're actually doing with what they say that they're doing in their reports. So the strategic report then is the mechanism through which reporting is conducted. So that is a report by the directors, which they need to produce at the end of the financial year, where they provide insight into the company's business model and its main strategies and objectives, describe the principal risks the company faces and how this might affect its future prospects. So far as you can see, this is about the company's business and of shareholder concern. They also need to, and now we sort of move into stakeholder concerns, they need to provide relevant non-financial and sustainability information, and also provide an analysis of the company's past performance and provide information to enable shareholders to assess how the directors have had regard to stakeholders and other matters when performing their duty under 172. So that model then is one of saying stakeholder interests, environmental interests can pose a risk to the company's business model. So if you have unhappy employees, if you have if your business model is affected by climate change, so you're the tourism industry and you're mostly organizing holidays to a part of the world which is becoming increasingly uninhabitable. So that is sort of a risk to the business model of the company, and that's of interest to the shareholders. The idea here is an enlightened shareholder value model. So the idea is that there isn't a class war between stakeholders and shareholders, but there is an overlap between those interests. So it is good for shareholders if companies have a happy and healthy relationship with other stakeholders. More on reporting. Quoted companies then need to say a bit more. They need to say, talk about the main trends and factors likely to affect the future development, performance, and position of the company's business. They need to give information about environmental matters, including, and that's important, the impact of the company's business on the environment. So that's not reporting about how does the environment how does it constitute a risk for the business, but rather how does it impact the environment. And then information about the company's employees and social, community, and human rights issues, including information about any policy of the company in relation to those matters and the effectiveness of those policies. So you can see the idea here is that quoted companies, those who are listed, need to say more about how they affect the environment, but also what kind of policies they have in relation to stakeholder interests. And then again, that is sort of a sort of slight nudge for companies to have those policies, so that because otherwise if they didn't have them, what would they report? So the idea is that sort of encourage companies to consider those interests and develop policies on this. There's guidance from the FRC. The FRC is the Financial Reporting Council. The Financial Reporting Council writes, for example, the UK Corporate Governance Code. And then there is something called a Section 172 statement. Now, for large companies, they must include a statement which in which directors describe how they have had regard to the matters set out in section 172, subsection 1A to F, when performing their duty under 172. So that is a specific statement. It's called the 172 statement, where in addition to reporting in the strategic report, a specific statement has to be delivered and published, where the director set out how they have had regard. Now, this can be approached in two ways, this measure or the reporting measures. You can either say it's just reporting, or you can sort of say there is sort of a behavioral encouragement there for directors to be more responsive to stakeholder interests. Now, let's move on to failure to prevent incorporate criminal liability. The UK does not have a general duty to require directors or companies to prevent human rights abuses. It's more of a piecemeal approach, and we can see an increasing use of failure to prevent due diligence requirements. The first one is the Bribery Act 2010, so quite a while ago. That triggers criminal liability for a company when a bribe is paid to obtain a business advantage for a commercial organization. Note, what triggers it is a bribe being paid to obtain a business advantage for a commercial organization. By whom? A person associated with that company. That can be an employee, an agent, a subsidiary. So these are people who may not necessarily be formally associated, so they don't have to be under direction of the company, but they're associated with it, and these are examples. And you can see there, this could of course have an extraterritorial reach. So there's liability unless a defense is available, and that defense is the organization or the company has adequate procedures designed to prevent the bribery. So the organization is liable if an associated person pays a bribe, and then there's no liability if they can show that they had adequate procedures. Here, deferred prosecution agreements are common, and you can see 2010, so we've had some time for this to bed in, and usually what happens, there is a fine that is agreed on, and then compliance programs are implemented. So that's part of the agreement between the prosecution service and the company, where companies pay a fine and then commit to compliance. Other examples, the Criminal Finance Act is something similar here. Here we've got two offences. One is the failure to prevent UK tax, but also the failure to prevent foreign tax evasion. Now, what you have here, it applies to corporate bodies and partnerships, and examples of businesses which are likely to be need to be very aware of this are financial services providers, accountants and lawyers, but everybody else. Again, liability is triggered when an associated person facilitates criminal tax evasion, and examples of an associated person are again, an employee, an agent, otherwise somebody acting on behalf this corporate body or partnership. And again, the defense is reasonable prevention procedures. So we've had bribery, we've had financial tax evasion, or rather foreign tax evasion, UK tax evasion, and if sort of an associated person of a body corporate facilitates this by someone else, then they are liable, and there's guidance by the Ministry of Justice. Final one on this, there's the very recent Corporate Crime and Corporate Transparency Act, which has nine new criminal offences for large companies which satisfy 2 out of the 3 following criteria. So they have either more than 250 employees, or more than 36 million turnover, or more than 80 million of total assets. And there are 9 fraud offences. One of them is fraudulent trading. Liability is triggered if an associated person commits one of those offences, those fraud offences, intending to benefit the company. And again, the defence is reasonable procedures that the company has in place to prevent these offences to be committed. So the hard work here is carried out by reasonable procedures. What do companies need to do? They're encouraged to conduct some risk assessment. They need to, there's a sort of a proportionality requirement. So the ideas of risk-based prevention procedures, so not zero failure. The defense is made out when the sort of the procedure is adequate to prevent those offences from occurring. So it doesn't have to be completely failure proof. Top level commitment needs to be shown so that the board has some involvement in setting out those procedures. Due diligence on counterparties, people that the company or corporation interacts with, and communication within the organization, including training, and then a feedback loop through monitoring. Do these procedures work? Where do we need to review them? Do we need to set them up in a different way? So there has to be, there's a reasonable procedure has a sort of a situation where they're enforced, but also there's an ongoing process of improving and reviewing them. And if a company can show that this happens, then they have a defense to criminal liability. The final one I'd like to look at is the Modern Slavery Act, which does two things. It puts in place criminal offences of slavery, servitude, forced and compulsory labour, and human trafficking. These are big problems in the UK, as I'm sure everywhere else, where you've got people that are being taken advantage of. And so these are new 2015 criminal offences. There's no failure to prevent offence. So the Modern Slavery Act is not quite as developed as the Bribery Act or the recent Corporate Transparency Rules or the Criminal Finance Act. They're just reporting requirements, and companies need to issue a modern slavery statement. Those are all large companies with a business in the UK and that have a turnover of more than 36 million. So in that statement, the company needs to set out the details of the steps taken to prevent modern slavery in supply chain and in their own business, or a statement that no steps are taken. So you can see that's actually quite a weak measure. You can either say set out what you're doing, or you say we're taking no steps. But if you take no steps, you need to publish that. The idea and hope then is that the public will monitor and police this. There are some suggestions for reform where, for example, the government takes a stance that they might consider this in their procurement, so that a government contract can only be awarded to businesses that have a modern slavery statement. But that is under discussion. So for the moment, companies can choose to say we take no steps to prevent modern slavery in our supply chain, or they issue a statement saying what steps they're taking to prevent modern slavery. Okay, so here again the three topics I've spoken about. One was the Companies Act 2006 and its drafting, which requires directors to have regard to stakeholder interests and is supporting by reporting requirements, and then due diligence requirements in criminal law, and then finally reporting requirements under the Modern Slavery Act. Thank you very much.